What's up, everyone? My name is NINAAD and I'm a legal intern at LEXIS and Company, and I'm also a student of the Maharashtra National Law University, Mumbai. In today's video, we're going to be talking about parliamentary privileges and the uses and misuses in the proceedings of the Parliament of India. Let's get started. Parliamentary privileges form an immensely vital part of the conduct of legislative business in the Parliament. It refers to the freedom of speech and expression to put forth all sorts of opinions and suggestions without any restraint or any kind of restriction, and it is a feature that enables all sorts of creative approaches, bringing about a lot of important thought and dialogue in the parliament. The same thought is highlighted by very important provisions of the Constitution of India, which are Articles 105 and 194, which cater to this specific need by providing the constitutional authority of exercise of parliamentary privileges. Now, a lot of jurisprudence in this matter, ranging from the very important and popular searchlight case of Pandit M.S.M. Sharma versus Sri Krishna Shah and others, to other famous cases such as the P.V. Narasimha Rao case, all back the opinion that the freedom of speech and expression under Articles 105 Clause 2 and Article 194 Clause 2 are all very different from the freedom of speech and expression and the freedom to have any sorts of free thoughts under Articles 19 and 21, and hence there is no action that lies in a court in respect of these legislations. Further, the exclusive cognizance within the four walls of the Parliament also seems to have been accepted by the courts on the basis of subclause 3 of Article 105. Although these provisions on the face of it seem very straightforward, these have been fairly misused in their own ways. In this backdrop, there is a very important case of Raja Rampal versus the Honorable Speaker of Lok Sabha and others, which thoroughly questions the actual extent and applicability of the parliamentary privileges. Although this is a very important case, the decision made by the court is somehow erroneous in its own different manner. The court, in a sense, affirmed the ability of the courts to review matters which would otherwise fall within the exclusive cognizance of the Houses of Parliament. It held the doctrine of exclusive cognizance, which was discussed in the case of Bradlaugh versus Gossett, inapplicable to the Indian scenario, and subjected the proceedings in the Parliament to judicial review on the grounds of arbitrariness and unconstitutionality. But a thorough examination of the Bradlaugh decision brings out the fact that the doctrine therein is not based solely on the views of parliamentary supremacy, but on the considerations of functional necessity, and cannot be held to be inapplicable to India solely on these grounds. Therefore, this ground for invalidating the application of the doctrine to India may not have been available to the courts at all, given that parliamentary sovereignty is not really essential to the concept of the privilege of exclusive cognizance. The court has therefore seemingly erred in analyzing the actual applicability of the doctrine of exclusive cognizance. The decision has tampered with the parliamentary supremacy by subjecting one of its most fundamental aspects to judicial review, hence diluting the sovereign power exercised by the parliament in this respect. Hence, as it is, the doctrine of exclusive cognizance should definitely, in my opinion at least, be kept in effect in its complete essence as long as there is no particular question of grave concern at hand. The question can be a question pertaining to the life and liberty of an individual and not otherwise. That is all for this video. If you learned something from it, do like, share, and subscribe. Do comment down below any questions, any queries, any suggestions, or any opinions that you might have regarding this topic. And that's all. Thanks for watching, and I hope you have a good one.